Good morning, everyone. It is my pleasure to open the next session, or the first session of this morning, and congratulations for all of you who made it on time. It's much appreciated, and also to everyone online. I would like to start before also introducing the panel with a presentation. The topic, as you can see, which is the panel number 4, is on interoperability and data portability. So to basically kickstart the panel, I've prepared a slide for you. So my name is Reimsbach. I'm a member of the OECD Secretariat, serving the Data Governance and Privacy Working Party of the OECD. And essentially this presentation builds on work that we have done at the OECD, also in collaboration with our competition colleagues. And I would like to start obviously with the definition. What do we mean by data portability? And this is actually very important because very often when people talk about data portability, it's not very clear whether they mean data sharing more generally or what the difference is. So this is what you see essentially is a working definition that we propose in our report, which is basically saying that data portability is understood in the context of this report, and this is what we are putting forward as a working definition, maybe also for the panel, but the panel should feel free to actually also disagree or endorse this definition, and this is also true for the audience. It essentially is the ability or right of a natural or legal person to request that a data holder transfer to the person or to a specific third party data concerning that person in a structured, commonly used, machine-readable format on an ad hoc or a continuous basis. And I think part of the discussion will focus a lot about some of these aspects. What you see on the figure is essentially a framework that we use in our work on data access and sharing to basically say that openness, or it has different degrees, and there are, let's say, more extreme forms of data openness when you think about data sharing, which is essentially what we call open data, which is here categorized as level 3. But then you have more restricted regimes, and data portability is one of those more restricted regimes in that it really is the data subject when we are talking about personal data, or the businesses basically involved in the creation of data that has the ability to initiate the transfer. And this is really the key aspect that differentiates data portability from, let's say, other data sharing regimes. Now, what is also important, because the session is also about interoperability, a proposed working definition is basically that data interoperability is the ability of systems, and this can include software systems or applications, to exchange data such that these systems can work together. This will typically require continuous real-time transfer of data. And I think yesterday we talked a little bit about that notion of what do we mean by continuous real-time transfer of data. But it is an important concept to at least a good starting point for our discussion. Now, in our work, we actually had a framework that we used to map different data portability measures. And you can differentiate essentially those measures, whether they have a sectoral scope, whether they are horizontal or sector specific, who the beneficiaries are, and this includes in particular if we are talking about individuals or organizations, the type of data that is basically subject to data portability, whether it's inferred data, volunteered, observed data. So this is one of the categorizations that have been discussed. What kind of legal obligations are attached to that? And most importantly for our discussion today is the last one, which we refer to as modus operandi, which essentially is distinguishing the transfer mechanism, whether it is ad hoc, whether it is ad hoc direct transfer via a third party, or whether it is real-time continuous data transfer. And the link here is important because that's, at least in our thinking, when we worked on the report, the link between data portability and interoperability is really determined by that last aspect. Now here what we did was to essentially, as we reviewed different data portability regimes, we looked into also the history of data portability. And what is interesting, so data portability 1.0 essentially is the ad hoc data downloads, which essentially were the earliest forms of data portability measures. And very often they were based on a voluntary base, like you see the Blue Button initiative in the United States. But what is interesting is that you can see a progression towards real-time continuous data sharing over time. And so if you look at the more recent kind of regimes, they have more emphasis on the real-time transfer, whereas in the past, the emphasis was more on allowing users to download their data. And this is an interesting observation. Now, one of the important points is that obviously data portability is not only attached and comes with benefits and opportunities, which you see on the left-hand side related to competition and consumer choice, simulating data-driven innovation, facilitating data sharing and data flows, and then in particular in the privacy context, when thinking about the GDPR data portability right, it's also about achieving informational self-determination. But you see that you could say even attached to each of those opportunities are kind of related risks. So if we take competition, which has been the focus of our discussion today, the work that we did also in collaboration with our competition colleagues showed that there may be unintended adverse effects on market structure, which is basically also tied to the fact that data portability could actually reinforce in the market power of incumbents, which by the way is also one of the reasons, because we discussed this yesterday, why for instance, the gatekeepers are to some extent excluded from the data portability rights, and this is one of the reasons why we have this kind of exclusion, at least in our thinking. But you see, there are different kind of risks that one needs to take into account when thinking about the opportunities as well as data portability. Now, this is the last substantive slide. Essentially, we also looked into the implementation challenge, and I would like to emphasize, I won't go into all of these, but I would like to emphasize in particular the two last, because this is, interestingly enough, when we prepared our panel 2 weeks ago, the panel kind of was in agreement that these were the kind of the two key topics, which is on one hand, the relationship between data portability and interoperability. And the other theme that we also wanted to discuss is the interplay between the relevant legal frameworks, which touches upon or leads to the consequential need for cross-agency regulatory and enforcement collaboration. So with that, I mean, I assume that the slides will be shared, so you have here the reports that we did in the context of our work on data portability, and you have here a list of some of the other reports, but this will be shared with you. So with that, I would like to open the panel and start the presentation. As I said, we will have two major themes. One theme will be on the importance of data portability and interoperability, and in particular the interplay between the two concepts. And I would like to open the floor, or the panel, by giving the floor to Steffen, who is a professor at Nova School of Business and Economics. So the floor is yours. And just to explain what you can expect now, we will basically have 2 rounds of comments. So I asked our panelists to be relatively brief, so that we can have 2 rounds of comments, and then we will see how it goes.
Okay, thanks a lot. I'm also a member of the Scientific Council of the Center for a Digital Society. Okay, yes, I have to be very, very brief because this is what was asked from me. I was also asked to take a step back, and first of all, I want to remind that essentially what we are talking about is part of a long story of investigation, research and policies that are related to network effects and compatibility. So these are things that have been looked at since the 1980s at least, and a lot has been written about it. And so how things work together, how we can work things together is important because of network effects, okay? And we have to distinguish between the firm level and market level network effects. We have network effects when essentially everybody knows that, but I just say it. We have network effects when the benefits that a single user obtains from a service increases with a number of other users. And so with data, that is of course true as well. We want to spread the network effects as wide as possible from firm level to market level because of the efficiency that creates. On the other hand, These network effects, they create conflicts of interest between the different participants in the market. So in particular, those who are incumbent, who already have large networks, or in this case, a large amount of data, they have an interest in denying access or not giving access to anybody else because it gives them a competitive advantage to be the only holder of this data. So therefore, there's also a competition policy point here, which is to try to open the network, so to speak, to everybody else. So we have a second objective here, apart from efficiency. The second objective is to keep the market competitive, contestable, and so on. And these objectives, and this is one thing that we can discuss on the panel, whether they are actually conflicting or whether they are complementary. Okay. When we discuss the different kind of legal requirements that we saw from the different acts yesterday, the DMA, the DA, and so on, we should keep in mind that they do have one of these two as a main objective, and they quite often they're not the same. On interoperability, the important parts of the definitions, actually the definitions in the DMA and DA are very similar for interoperability, not identical, but similar. Exchange of information and to provide a certain functionality. It's the two things, information and functionality. But it doesn't go into much detail what kind of interoperability we are actually talking about. There are many different levels of interoperability. There's at the technical level, at the service level, the standards level, and so on, and this will really depend on the context. Portability. I didn't find a definition of portability in the legal texts. It's funny, we have one for interoperability, but not for portability. Maybe it's obvious, or maybe it isn't. So also one thing that we can discuss. The relationship between the two, we need some kind of interoperability for data portability, but at a more basic level. So we don't need service, for example, we don't need service interoperability to create data portability. That's a different level. So just to sum up what I wanted you to take away from this, keep in mind we have these two different objectives, efficiency on the one side, competition on the other side, and when we look at how they work together, there may be trade-offs or maybe not. Thanks.
Thank you very much also for being brief. So we will now move to the next presenter. Chiara is Deputy Head at the Economic Analysis and Digital Affair at ARCEP. So with that, please, your brief starting statement. Thank you.
Thanks a lot. So for interoperability, of course, from a telecom perspective, it's a very powerful regulatory tool. And what is important to understand, it is a tool. So it is not an end in itself, because sometimes we talk about interoperability as it is like we have to reach interoperability. And of course, it has to be taken as a tool, which allows for reaching different objectives. And the objectives will be can be different. There is a variety of different objectives that you can reach with this tool. And I will add one more to those which were mentioned by Steffen, because actually in the EECC, so the European Electronic Communications Code, we also have interoperability measures for a number of independent interpersonal communication services, which is a very complicated term to say just services like messaging services or video conference services or email services, but for email services, interoperability is already there. But if we take, for instance, messaging services, we find interoperability measures under two regulatory frameworks. So the DMA now with Article 7, and also the EECC, so the Telecommunications Code with Article 61.2. And they are there under different conditions, potentially targeting different actors. And they are triggered by different objectives. So the objectives in the DMA is contestable and fair markets, but in the EECC, so Telecommunications Code, it is to reach end-to-end connectivity. So when there is end-to-end connectivity which is endangered, you can use this kind of measures. So it's very different at the end. The reasons which explain the imposing of these measures. And of course, then the interplay between these two frameworks is key. And we will see it also afterwards that how to organize this kind of interplay and this coherence and consistency between the two frameworks. And also between the Data Act and the DMA, of course, the interplay there is also key, because you have in the DMA, you have real-time data access obligations and real-time portability, and which means basically data interoperability, so when it is real-time. And in the Data Act, you have the same, you have measures for interoperability, data interoperability and data portability. And what is interesting, actually, from a telecom perspective as well, is that there is no perfect solution when you want to, you're looking for the implementation solutions for interoperability measures. There is no perfect one. So it always depends on the objectives and on the context as well. For in the telecom sector, we went for standardization. So SMSs and telephony, they are standardized. But in the DMA, for services which are also communication services, like messaging services, maybe the Commission will decide to go for a different solution. For instance, they may decide to go for APIs. And APIs, compared to standardization, they are more dynamic. But of course, as you were mentioning before, there are also risks. Because, for instance, there is no technical reasons for choosing between two different gatekeepers, for choosing the same implementation way of, the same way of implementing interoperability through APIs, so choosing the same kind of APIs. So there is no technical reason for choosing the same, so there could be as many APIs as you have gatekeepers in the market. And of course, if you are a small provider of messaging services, and you can choose between messaging services, which is provided by very big platforms with lots of network effects, as it was mentioned before, or a smaller one, then of course you will choose probably to implement the bigger platforms APIs, which may reinforce even more the market power of the company. And maybe another lesson learned from the telecom sector is that in the DMA, you have under Article 7, so you have the obligation for the gatekeepers to publish a reference offer. So for those who are not familiar with reference offers, it's actually a text, a document where you have all the technical details and to enable this interoperability, so technical and contractual as well, details and specifications. So there is the obligation for the gatekeepers to publish this offer. And in the DMA, it sounds a bit like you just have to publish it. The European Commission can consult BEREC to make sure that this reaches the objective of interoperability. And then it's done. You have the reference offer, you can interconnect. But actually what we learned in the telecom sector is that once you define the content of the reference offer, then you will update it, and you will update it like very regularly. So it's not like it's not one shot. So for as BEREC, because I'm also co-chairing the working group on digital markets at BEREC, and what we did, we drafted and we prepared a list of minimum criteria for the reference offer under the DMA. And then what we added is also very key, because it's like, okay, now this is the content, but then you have to make sure that there is a process of updating this content. And as telecom regulators, so we've been regulating the market for 25 years, and still we are discussing regularly with stakeholders and access seekers on how to update the reference offer. These kind of exchanges and updating and like collecting really relevant information from market players is really key, and it's something that the DMA will work only if this is foreseen in also by the European Commission. And also it's what the regulation is about. So these constant exchanges with stakeholders and constant updating of the measures to make sure that it works.
Thank you very much. And I think we will definitely get back to the question about the interplay, because actually now I already have one question that I would like to ask you, but we will keep that for after the round. So we move to the next presenter, who is Chris, who is Director of the Digital Market Unit at the Competition and Market Authority of the UK. So Chris, the floor is yours. Thank you.
Thanks, Christian. So I just wanted to build a bit on previous speakers. I'm coming from a competition perspective. Our starting point on lots of this is data can be a significant source of market power, or a thing that can allow some of these big firms to exercise a dominant position. So data remedies can have significant benefits in terms of facilitating switching and overcoming network effects. And I think we had a good discussion about theories of harm yesterday. I mean, again, just to build on some of the points that Christian made, I think it's important to distinguish between different types of data remedies. when we were looking a few years ago at online platforms and digital advertising, we came up with a bit of our own taxonomy, which included first kind of remedies for increasing consumer control over use of data, which I think links to data portability and mobility. Second, mandating interoperability. Third, third-party data access. And fourth, kind of the opposite of data access, so data silos or separation within big ecosystems. And I mean, I won't try and kind of go into the relationship between all those. I see them a bit as overlapping, kind of like a Venn diagram almost. But I think in some ways, it's important to get into the details of specific markets. So I'll come in a second onto some of the work we did on open banking, which I think is a good example. Sorry, is that better? Yes. Okay. Just one thing I think is useful to distinguish is between vertical and horizontal interoperability. I think when we're thinking about both efficiency and competition impacts, there can be some differences. So by horizontal interoperability, I mean interoperability between substitute products, so firms competing in a market. By vertical, I mean complementary products. And both of those can be beneficial, but I think sometimes the analysis is slightly different. So to go on to the practicalities of open banking, I'm aware, I mean, open banking is something which has been kind of implemented in various different countries now. So I'll just talk about the UK experience. The remedy was initiated in 2017 following a market investigation carried out by the CMA. And we were focusing really on retail banking services and lack of competition in retail banking, both in personal and business current accounts. So I think there are some interesting features because it came from a competition perspective here. Because it was seen as something which was a competition issue, we actually got the largest 9 current account providers to create and fund an open banking implementation entity, and through that to agree, adopt and maintain common, open and free to use standards for open banking. So it's important, I think, to say that data mobility in banking did exist before our intervention. So there was something in the UK called My Data, which allowed consumers to port their data between accounts, but it didn't really gain traction because it relied on consumers to do the action. I think an important lesson in open banking is the need for some kind of interoperable standards to allow, as Christian said, kind of real-time porting of data, which is activated by the firms rather than the consumers. And I think there's been some success. So today, there are over 330 regulated firms in the open banking ecosystem, over 7 million users of open banking powered technology. It's estimated that over half of the UK population will be using open banking payments. So just stepping back on some of the lessons that I think might be interesting to take into some of the other discussion of interoperability remedies. So first, I think to be positive, it demonstrates that an interoperability remedy can be implemented and appears to be relatively successful. As I said, I think it shows the importance of having common standards. Data portability in itself is maybe not enough. The second is, going back to my point about horizontal and vertical, I find it quite interesting that interoperability can enable innovation, particularly in complementary services. So from the CMA perspective, the core concern in the market investigation was a lack of horizontal competition between banks. The remedy was attempting to ease switching basically between banks. And it has done that, open banking has done that, but it's also encouraged innovation in complementary services, and that's probably the most striking impact. And something where we wouldn't have known what innovations were coming, but I think the fact you've got the open banking APIs allows firms to build on them. The third lesson is successful implementation needs regulatory oversight and technical expertise. We're talking here about a sectoral, a specific sectoral intervention. It's clearly creating the technical standards is complex, and I think it's really important that industry is involved in that process. But with regulatory oversight, so that the objectives which we're trying to get at, opening data to encourage competition is what actually is achieved through the APIs and standard setting. A fourth point is results take time, so this does require persistence. I suppose it's been around 6 years it's taken to fully implement the standards. We've now gone into a transition phase where the CMA is no longer involved, and really the kind of continuing oversight of open banking has moved to the Financial Conduct Authority and the Payment Systems Regulator in the UK. So they're extending some of the existing APIs, but it's taken, I suppose, 6 years to get the core functionality working, and importantly for the market to adjust, for innovation to happen around it. And final point is need for the scope to be clear and the importance of governance, where again, it's been, I think we've learned sort of through the process, some lessons on how you kind of carry out good governance in these types of processes. So hopefully that's helpful as a kind of practical example of how interoperability and data mobility can work.
Thank you very much. And I have actually one question that I will ask. I've noted that, and I think I will ask that. And I just also to prepare the audience that we will actually open the floor for a first round of question before we move to the second theme. So be prepared to if you have any questions in mind. But before we do that, we will have the final speaker of the first round, who is Begoña, thank you.
It's okay, Bego's fine.
Who is our senior researcher fellow at the Max Planck Institute for Innovation and Competition, and gender equality officer, I saw on your profile. So with that, the floor is yours.
Thank you, Christian. Can you hear me well? Yes? No sound problems? Good. So good morning, everyone. Well, they already cover a lot of ground. So for me, the challenge comes on what to add to the discussion. But I would like that we all take one further step back, not just historically, but just looking at the title of the conference or the panel discussion, not just today, the 2 days. No, it's Global Data Governance. But we have been focusing on the European Union, most likely. So the data strategy, mainly the DMA, mainly the Data Act, which is fine, but it's a bit Eurocentric, maybe. And maybe that's also, and that's also one of the questions that I want to bring here. We have heard about objectives of interoperability and data portability. We have heard of goals, efficiency versus the need to keep the market competitive. It's true, interoperability, data portability are very context dependent. But then when we look at Europe, just comparing to the world, we also see when we look at the Commission, the current Commission and their data strategy, that we are in the middle of a paradigm shift. Under Juncker Commission, laissez-faire was like kind of the guiding principle. And suddenly we have a Commission that is super interventionist. We have a lot of, I don't know if anyone can keep track of the amount of acts or proposals that are related to data. The question is, we heard yesterday, data is the new oil. Well, and we can disagree on that because of the what it's oil or the characteristics of one good and how data behaves. But the truth is that we want to reap the benefit of data, and that's not just at the European level. However, what we can see, or at least that's my perception, and please correct me, I mean, I'm open to be rebellious on that. What we see here, at least at the EU level, is that we're fighting against the power of platform monopolies. So it's a fight against these big techs, in a way. And this fight against digital monopolies, I mean, we see that we want more contestable markets, more in the fairness in the markets, DMA, but we also want to enhance consumer welfare, whatever that means. We want more EU-based innovation, more radical innovation, more incremental innovation. Isn't that a very static approach? Shouldn't be actually trying to have a much more dynamic approach and just think that the platform economy is part of the digital economy, but it's just one part. There is much more. So my proposition here to now open the discussion is that it's true, and I completely agree that interoperability and interoperability are tools. So they are a means to an end, not an end in itself. But they help in the design of data governance frameworks because they are intertwined and embedded when the regulator designs data access regimes. And because of these are also pro-competitive measures, that also binds the regulator to what we were talking yesterday about, this market failure, specific regulatory interventions that need to correlate to these data access regimes. Yet, when the regulator, or when we think about how to implement or how to add to these data access regimes interoperability obligations or conditions, or as a remedy, or data portability types, degrees, that also conditions the way that data access regimes functions, and overall it conditions the way it might be enforced. So it's super important to also think from that perspective. But then having that into account and considering that the design of data governance frameworks, it's so close to these two tools, shouldn't we also look at just taking all the effects of digitalization in consideration? So not just the fight, so the competition, let's say, approach, which is fine, but there is also social, political, environmental considerations that need to be taken into account so that we can actually maximize this benefit sharing that is what we want to achieve at the end with data sharing. So that will be my question for you. Thank you.
Thank you a lot, Begoña. And maybe I've before we open the floor to the audience, I don't know, do we have already questions that people want to ask? Because interesting. We have 2 questions, so that's already good. So maybe I will share very briefly my questions, and we will collect also questions from the floor, and then we can see. So I guess the very first question that I had was like, also listening to the different interventions, it seems that the kind of common theme is that exactly that those dual objective, or I wouldn't say conflicting, but I want actually to hear your view on how you think about those objective of efficiency on one hand and contestability. You actually talked, Chiara, about the objective for end-to-end communication in the telecommunication context. And to what extent does it really matter to have those different objectives if at the end of the day the result is the same? And maybe it ties to what you said about the condition, how those objectives are enforced. Maybe this is the impact that it will have. So this is my first question. The second question is about the role of open APIs. To what extent do they really need to be open? And what is the role of copyright in that context? And I don't know if we can collect the 2 questions from the floor now, and then
Hi, Antonio Manganelli from Lumsa University. Just a question mainly on interoperability, referred mainly to Article 7 DMA, but also very generally speaking. So one of the critique about interoperability obligation, which in a way try to balance the two, the productive efficiency and locative efficiency, so the competition and the internalization of network effects, is that could reduce multi-homing in digital platform, which is the current way in which some competition is developed in the market. And but A couple of considerations on that is that multi-homing, in a way, is not working so effectively, and all the DMA is based on the fact that multi-homing is not working. And on the other side, maybe multi-homing, it's kind of second best in the minimum that could be, considering the economic features of digital market, so the tipping of the digital market, multi-homing is kind of like a competition for the market, in the meaning that at a certain point, maybe it could be a disruptive evolution, and one of the small player, multi-homing, could take the place of the big guy. Why? But this is the second best, why interoperability could introduce more competition in the market, so could be more beneficial. But that's the question. What is your opinion about the relationship between interoperability and multi-homing, and if really the obligation in the DMA really is facilitating competition in the market? Because, for example, there is any specific provision about switching, which is at the end could be the main outcome about interoperability and competition in the market.
One more question, and then I will ask the panelists to answer the questions.
Thank you. My question is for Chiara, and if I understood clearly, Chiara, and it's regarding Article 7. You mentioned that ARCEP is working with BEREC on reference offer, if I understood correctly. Can you tell us a little bit more on this, if it's possible, and if this kind of documentation will be available to potential companies that would like, to benefit from Article 7 at some point? Thank you.
Thank you very much. And maybe to answer, I won't answer the question, but I would like to direct the first question from the floor to the OECD report on data portability and competition, which actually addresses that very well. So our colleagues have but I just wanted to basically point you to that. But yes, who wants to answer, take the first shot at the many questions that we have received? Maybe we go in the order of...
Okay, thanks. As concerns the trade-off between, or potential trade-off, well, actually I asked the question, right? Are these two objectives of efficiency and contestability necessarily in conflict, or are they complementary? And it probably, my own answer would be, depends on the context, right? So there may be situations where you could have both. And in particular, I think in all the discussion, we are giving a lot of attention to the Digital Markets Act and market power, and a lot less attention to the European data strategy, which is all about efficiencies. It's not about market power. And so when we look forward to having a common data economy as envisaged by the Commission, the efficiency is really much more important than the market power issue. In terms of whether there is necessarily a conflict, I would have to think about specific examples. Need some more time here. I would like to comment quickly on the question of interoperability on multi-homing. So, yeah, we might see less multi-homing, but it wouldn't mean fewer providers, right? Because then instead of people being on multiple networks, we have multiple companies being able to exist in the market more easily than in a setting with multi-homing. So in that sense, that would be an improvement, right? Because with full interoperability here, we would precisely move the network effects from firm level to market level, and therefore get rid of the tipping. And of course, in order to get this, you also need portability, so that people can actually move their profiles from one operator to the next, to be able to actually make use of that.
Just very quickly, because you pointed out to the importance of the EU data strategy, and I think something that is maybe sometimes let's say, ignored. And this ties to your question or to your comment, Begoña, about how do we take into account other kind of policy or societal objectives. And I would say one of the means that we have seen in other OECD countries, how this is being done is actually indeed through national data strategies, because those national strategies typically have, let's say, other societal objective as a goal. But I mean, in the context of the EU data strategy, as you pointed out, some of those other objectives may not have been articulated very strongly enough. And yeah, we can maybe discuss at a later stage or offline why. But I just wanted to make the connection between the data strategies and your.
Okay, so on the three questions. So the first one about the objectives. So I think the objectives actually, it has two different impacts. The first one is that according to the objective, it determines how you will use the interoperability obligations. Because in the telecommunications code, then you cannot use it just because there is market power. You have to use it because you have analyzed and you see that there is end-to-end connectivity which is endangered. So of course, then the objective which is stated in the regulation then gives you certain power to adopt and to implement this interoperability measure. So this is the first impact. And the second one, it is about also the implementation solutions, because according to the obligations and according to the context in the market, in the industry, you can choose either APIs or standards, for instance. And of course, in the DMA, it will also depend if there is a kind of critical mass from the industry around specific standards, which it's not something that we observe for the moment. In that case, then the best solution could be to reach this objective could be the standardization, or otherwise it would be APIs. But I think it's an impact about for like, can you actually implement this measure or not? And the second one is how you will implement it. So the objective in this case can be, I don't know if it's conflicting, but let's say determines like the path that you will take. On the second one by Antonio, so on multi-homing, I think multi-homing was mentioned a lot as an alternative way not to impose interoperability, because they say in any case there is multi-homing. Multi-homing is possible, it is free from monetary cost. And so in that case, I mean, you can just have as many applications as you want. But for instance, at BEREC, it was in 2021, so maybe the data changed a bit in the meantime. We published a report where there was a survey to see like what was the behavior of consumers in interpersonal communication services. And there you see that they do multi-home, and they multi-home between WhatsApp and Facebook Messenger a lot. So I say, okay, but then 84, I think it was, % of consumers were using these two applications. So you have the impression that they multi-home because they use two different applications, but these two applications belong to the same company. So at the end, is it really competition in the market? So it's actually multi-homing. I would soften a bit like the importance that is given to it, and just to go a bit behind, okay, but what is happening actually? What do they multi-home with, and how much time do they spend on each application as well? And the second, so related to this, I think once you create interoperability, of course it can just lower than multi-homing, and just people would just stay on the one application. But there, I think there is a strong complementary tool which has to be used. It's consumer awareness, you know, raising consumer awareness of like what kind of applications are in the market, what are the features which comes with this, also in terms of treatment of personal data or security and so on. Because we saw, for instance, some years ago, there was a big flow, let's say, of users going from WhatsApp to Signal, and it happened just because there was the update of terms and conditions in WhatsApp, and the users were immediately aware that data were used, and they said like, okay, but then we will switch to different services. So there is actually this kind of movements. I think it will also come once the awareness of the users will be raised and they are more empowered. So it's just not an action which will come from top down, like, okay, we impose interoperability, then it will just happen and work and change the market structure. So I think it really comes also with the consumer who will also take a bit, use this right as well from their side. And on the third question by Audrey, so yes, I have, let's say, two hats, and we say in French, so in ARCEP and also in BEREC. And BEREC is also for the telecom sector. We prepare at BEREC a list of minimum criteria in the reference offer. And this is something that the European Commission and the legislators also put in the DMA. So in the DMA, in Article 7, there is the obligations for the gatekeepers to publish this reference offer. And there is the possibility, not the obligation, for the European Commission in Recital 64 to consult BEREC once the gatekeeper publishes this reference offer. The European Commission can consult BEREC to see whether this reference offer is in line with Article 7. So as BEREC, we took a proactive approach, and we said, okay, we published a report where we already defined some criteria which we think should be in the reference offer for sure. So it's something that we produce up front, so before the implementation of the obligations of the DMA. And so as ARCEP, we are not directly intervening in this reference offer or in the DMA, but as BEREC, we do, because there is also the high-level group in the DMA, which was mentioned yesterday, and I think we will talk about it afterwards as well. And there is the possibility for the European Commission to liaise with BEREC in order to determine whether this reference offer works. And the reference offer will be public, so it will be accessible for access seekers, as we call it in the telecom sector, or competitors who would like to interconnect with the messaging services of the gatekeepers. So.
Thank you. I move to the next speaker, Chris.
Okay. So quickly on efficiency and competition, I think my starting point would be they're very often complementary. I think we heard yesterday about sort of discussion about value of data and the economic characteristics of data. I think the bottom line is kind of allowing more data access allows other people to build on it, reuse the data in efficient ways. And in these cases where we have platforms with market power, also be able to share the network effects. So I think both of those, in principle, are kind of pro-efficiency and also obviously pro-competition. I think where you can get the efficiency, potential sort of efficiency trade-offs are, firstly, in terms of does it damage the incentive on a firm to collect data in the first place? And I think that's, again, very specific to the type of data. As we heard yesterday, some data is almost kind of accidentally collected by the firm just by nature of the product it has. In other cases, then there's more investment going in, and there we should be more worried about what the impacts might be. And the second sort of related to that is in terms of damaging innovation to the products. And I know, I mean, rightly, when we think about interoperability, I think it is important to think about so Antonio's points about kind of competition for the market and competition in the market. Is there are you risking kind of freezing innovation in the core market and not allowing the platform to kind of innovate, although you're getting more competition? And again, I think I won't sort of go into the details answer to the other questions, but I think it's a linked point both on role of open APIs and sort of multi-homing and interoperability. I think it really goes into the design of the interoperability remedy. When we were thinking about, in our market study, about ways you might increase interoperability in social media, for example, I think there are some things which are fairly discrete, like, for example, sharing contacts, being able to sort of share contact details between different social networks. That's a form of interoperability, which I think has fewer risks for efficiency, as opposed to kind of trying to design a kind of completely interoperable social media network. So maybe I'll stop there.
So, well, maybe jumping also on the question that you phrased about the role of open APIs and intellectual property rights. No? Well, I think from the IP perspective on APIs, I think both at the EU and the US, I think we're overcame that question. I think with the SaaS case and then what we have with Google, Oracle in the US, it's quite clear that when we're looking at software protection, copyright software protection over the API, so the application programming interfaces, that copyright should not play a role there. And actually, I would like just to bring also attention to another case that it's been, maybe it's not related straight to APIs, but it's related to technical standards, and it's before the Court of Justice and the Medina, so the General advocate released yesterday. It's just his opinion, or it's just the opinion, but we'll see then what happens with the court. But it raises, so it's public source and the right to access information against the Commission. And what the general advocate concluded is that there should not be copyright protection on technical standards, which I think it's also a huge step forward, thinking that to get access to these technical standards, you need to always to pay this 100 euros fee. And if you think about the development of AI and all the technical standards that AI systems will have to comply with the AI Act, and so it's a huge investment, so and compliance costs, let's say, also for startups or small companies. So I think we're going into the right direction from that point of view. And I mean, on the other, I think, I mean, I mostly agree with what has been said, so I don't have much more to add.
Thank you very much. And I would say with that, we can move to the second theme. I understand that we started 10 minutes later, so we may have 10 minutes more time. I'm looking at the organizer, seeing if everybody seems to be fine with that. Good. So we basically now we'll talk about the interplay between the relevant legal frameworks, and obviously what that means as a consequence for cross-agency collaboration eventually, or in cross-agency enforcement. And with that, I would like to open or give Begoña the floor to start the second round.
So, okay, let me start by just reading for you a conclusion reached on one of these OECD reports that I think it comes perfect, to what we're talking. The report came to the conclusion that portability and interoperability measures implemented with objectives other than competition may not have pro-competitive impact unless they are designed with market dynamics in mind. So that bridges a bit what we have been discussing with what we are going in this idea that these measures, these tools are embedded and intertwined with the design of data access rights, and also how data remedies or interoperability, their remedies are also designed and then implemented. So I want just to bring a couple of points also for discussion. One, it's like from a EU perspective, we see the Brussels effect, and this Brussels effect is also taken not just with the, I mean, we saw it already with the GDPR and this extraterritorial application that it's there, but we also have these, I mean, in other regulations, we have that in the Data Act, for instance, And I mean, if we look, the DSA, so we have a number of other proposals and enacted regulations that are already. And the thing is that all these regulations contain data portability rights and also different interoperability obligations that will have to be implemented also elsewhere. And is this the best way forward? I mean, or is this the best way forward also to reap these benefit sharing in a more broad way, at a global level? So not that just ones or a small group are the ones that reap out the benefits and not the others. And then also we have been, I mean, that has been said, so I'm not going to go deep into that, but the fact that we have different notions on what it's interoperability, not just pro or for or in the market, I mean, vertical and horizontal, I mean, but, and same with portability. That also affects in the context. So if we don't have a common understanding, we risk that then the enforcement of data access rights becomes problematic, and that hampers in the end data sharing because, again, we don't have legal certainty, and we have enforcement problems. And just 3 words of caution, let's say, when we're thinking about interoperability mandates or even remedies or data portability, so obligations. One is we need to be also careful when when the regulator mandates standardization of APIs and let's say plug and play APIs, because in a way we could be risking, looking at these, as we saw at the beginning, opportunities and risk, that yes, plug-and-play APIs could provide better levels of data interoperability, talking about this continuous real-time, but they may also bring new challenges, because at the end of API, it's a door, and you get through, but you don't know what else goes through to the other side. We mentioned briefly yesterday unilateral conduct, and abuse of a dominant position. And I was surprised that nobody talked about the Google NL case and the GC pass, Because if you don't know, I let you know, so the Italian court has referred the case to the Court of Justice. And in this case, what was at stake was a potential abuse of dominance from Google, because they refused to find an interoperable way to integrate the GC Pass, which is an app from Enel that helps fast charging of your electric vehicles. One of the questions that the court has put forward, the Court of Justice of the European Union, is if Article 102 of the treaty must be interpreted as meaning that a dominant undertaking which holds control of a digital platform may be required to modify, and I stress that, to modify its products or to develop new ones in order to allow access to those products to those who request it. I think that's to reflect on that. And having said that, and just probably quoting what Chris said, we need to be very careful on how these data, so interoperability remedies are phrased, implemented, and then also enforced. And in this regard, a lot of collaboration, intra-agency, it's necessary, but we also should not underestimate that at international level, the role of policy collaboration is also super important. So what is happening, not just at the OECD level, but at the WTO, the UNCTAD, and that's also super important, and we should keep that in mind.
Thank you. Thank you very much. I would like to invite now Chiara to give your statement on this particular question about the interplay of the legal frameworks.
Yeah, thanks a lot. So I mentioned already before about the telecommunications code and the DMA, so I will skip this part. And there were many obligations of the DMA, data-related obligations, which were mentioned yesterday. So not to repeat, then I will focus maybe on another one in the DMA, which I think was not mentioned yesterday. And it also concerns data portability and other also obligations, actually, which is in the DMA. There is an article 613, which is about the termination fee. So there is actually that the gatekeepers cannot impose termination conditions which are disproportionate. Then, of course, the definition of disproportionate is not necessarily very easy. But this is actually, it also means, in my interpretation, considering that there is among the core platform services, you also have cloud services. It can also be, there must be also an interplay with the Data Act, where there are also discussions about the withdrawal of egress fees. So egress fees in the cloud sector, it means like what you are paying to leave the service, basically, so to migrate out of the service. So actually, for me, these two articles in the DMA and the Data Act, there could be an interplay between them. It could be, it means that, the European Commission will also have to think how they apply the DMA obligations about termination fees to cloud services providers, and in the Data Act, how it will work together. And then there were also another article which was about the combination of data under the DMA, so the provision of the combination of data for gatekeepers, unless they consent to it. And then when you read the Data Act, actually even if they consent, if the user wants to port their data to the gatekeepers, they cannot. So it's also there, you see like the fact that there are different actors which are targeted in the two frameworks, different objectives, it actually leads to different kind of obligations implementations, even if sometimes it is the same actors and it is the same services. So it means that really coherence must be found at the end. And I think that a way to find coherence, also because it's actually bringing together different backgrounds as well. So for when we talk about communication services, then of course telecommunications operators know a deal about it. When we are talking about personal data, of course, then you have data protection authorities. When we talk about market power, then of course you have competition authorities as well. And there is a way actually to do this is of course coordination among all these different authorities. And there's, so the experience for us is that we coordinate vertically, horizontally, and both of them together. So vertically, for instance, when we are at BEREC, we coordinate a lot with the European Commission, of course, and in the DMA, as I was mentioning, there is this possibility to work with the European Commission for the implementation of interoperability measures for messaging services. Then horizontally, what we do it horizontally at the European level. So within BEREC, for instance, typically we share our experience. And now with the digital regulations is actually even more, because before we were exchanging about the implementation of the telecommunications code, but now many members of BEREC will also be designated as a digital service coordinator under the DSA. And a big deal of them were also candidates for the Data Governance Act and the Data Act. So it means that BEREC will also become a way among members to discuss other regulations that will be implemented soon. And then another one horizontally as well, it's more at the national level. And there, of course, we have all these long standing exchanges with national competition authorities and the media regulators, where we also have to give like opinions on each other's decisions. Plus, as ARCEP, so in France now we have a discussion about the competencies under the Data Governance Act and Data Act, and ARCEP is also candidate for the implementation of these two. So it means that we will have to coordinate a lot, and there are coordination mechanisms which are foreseen, also with data protection authorities. So for sure, this is how it will work from now on. And when I mentioned also both vertical and horizontal, in that case, it would be in the high-level group under the DMA, where you have different authorities, bodies and networks at the European level of different authorities working together, and then working also with the European Commission. So it's a quite interesting mechanism for coordination which will be put in place, I think, to make all these regulations work.
Thank you. Maybe let me throw in a question, not just to also prepare the audience for potential follow-up questions, which is like, don't you think, and you meaning the whole panel and the whole group, that we are maybe ending up going towards a kind of messy situation where different countries may assign different regulators to different responsibilities, so that if you want to do a horizontal kind of coordination across countries, you may end up no longer talking to your telecom regulators colleagues, but you may have the data protection authority of another country, and which basically then leads to the question, do we actually need those different regulators? Shouldn't we kind of aim for a super regulator that does everything, like we have maybe in the United States with the FTC that has multiple responsibilities? So maybe a question to keep in mind as a follow-up question. And maybe another point, because we talked a lot about the interplay between the different regimes, but maybe what we should be focusing on is whether there are potential conflicts, because the conflicts are actually what really creates a problem. The interplay interplay seems very neutral as a term. So please.
Yeah, great. You just stole my question.
Sorry.
I wanted to make this question to Chiara. In the sense that since you are involved in these processes, so because when you look at the different acts, the Data Act, the Data Governance Act, and so on, they describe all these different entities, the competent authorities, but they don't point to any specific existing authority taking up these responsibilities. So the question here is informally some kind of coordination going on? Say that the same type of authorities will take up these responsibilities in the different European countries, or not? Or is exactly going to happen what Christian just said, right? That is data protection authorities in one country, telecoms regulators in another one. Of course, all these authorities, we will have to end up speaking to each other and trying to find the same language even, right? to talk about things. The other point that I wanted to make is a potential conflict with competition authorities, because what I see is something that's could be something that's similar to what happens in the telecom sector with network sharing agreements. So there, networks try to work together to reduce cost, increase efficiency, reduce the necessity for investment. But competition authorities in different countries, and the latest case was in Australia actually a few days ago, a court decision, come in and say, no, wait, you can't do this because you will be coordinating and there will be less competition in the market. And this goes back, of course, to the whole question of if we, so to speak, freeze in kind of standards, then a competition innovation, as for example envisaged in the Data Act, will be based on those kind of things that have been made interoperable or exchangeable. Whereas if we don't have that interoperability, then competition and innovation may be between systems. Okay, so again, it's the issue of competition in the market, competition for the market. So is there a conflict, a potential conflict between competition authorities and the idea that firms need to coordinate at sector level even to get interoperability, exchange data, and so on?
Thank you. I noted some questions in the chat, which I will pop up after everyone has made the intervention. So the next one, Chris.
Thanks. So if I just talk a little bit about coordination in the UK, I mean, I think the first thing to say is when we've thought about these kind of data remedies and the impact of data on competition, it's clear that, as we've already said, there's kind of a relationship between competition and efficiency, but also privacy. And that's a particular thing which comes out if you're thinking about sharing data. Naturally, the question is, well, if it's personal data, is that allowed under the law? Is it good for privacy or bad for privacy? So we, in the UK, we've tried to work really closely with the ICO, the UK Data Protection Authority, and I'd say in two ways. So this might be sort of generalizable, I think. One is the policy framework and the interaction. So how do we see our respective policy positions, and where are the, as Christian said, the kind of trade-offs and sources of tension? And second, kind of when we're actually implementing things in the market, how do we work together? Just briefly on the policy level, we published a joint statement with the ICO in 2021, where I think one of the things we were really keen to do is say that there's not always a tension between competition and privacy. Actually, the two can be complementary in lots of cases. I think, again, yesterday there was mention of consumer control over data. That would tend to be both a kind of good thing for privacy and also can be pro-competitive. I think the areas of tension that we particularly were kind of worried about are where firms can, big firms that have data essentially can use privacy as a reason not to share. And I think in those cases, we need to probe really hard, because there might be legitimate arguments, but there also may not be. Obviously, their incentive is not to share the data. So that then goes into the implementation. And I won't sort of talk in detail about it, but in our current Google Privacy Sandbox work, which is a commitments case that we got following an antitrust investigation, we're working kind of explicitly with the ICO. So within the commitments we agreed with Google, there's a role for the ICO to look at the impacts of the new Privacy Sandbox tool, which Google is developing as an alternative to third-party cookies. The ICO have a role in assessing privacy, where we, on the CMA side, are obviously looking at competition impacts. I mean, that's still playing through, it's ongoing, but I think is a really interesting example of where we've got kind of practical engagement of the two regulators. And just really finally, I'll mention the Digital Regulation Cooperation Forum, DRCF, just to get an acronym in, which is a sort of framework across, which encompasses the work we're doing with the ICO, but also includes the Financial Conduct Authority and Ofcom, the communications regulators, so the 4 regulators that are most involved in digital markets. And again, I think that is a forum which allows for both the discussion at that policy level, what are the complements and tensions, and then we hope kind of in the longer term allows for engagement on specific design of remedies or implementation. Yeah, thanks.
Thank you. I would like to see if we have comments or questions from the floor before I check the chat again.
I have a question.
Yes, please.
I exploit my market power of having the microphone.
Great.
I'm Nicola Galli from the CDS. No, so quick question. Is anybody afraid that too much interoperability and portability can lead to collusion? Like, besides like privacy, of course, as a way to, let's say, stop interoperability, like as a ground for not granting interoperability, is like collusion risk? Could the gatekeepers, large platform, hide behind, oh, I don't want to risk collusion, and so I don't want to share or be interoperable?
That's a good question indeed. And just to say that in our report, we actually addressed that question as well. And and we basically looked at some potential roles for regulators to play actually a role as a safe harbor kind of platform for allowing the exchange in a trustworthy manner. But I just wanted to maybe let our experts answer the questions.
So, quick answer is yes. Like longer or more elaborated is, we know that these are tools to achieve certain goals. And as we said, when the objective is not to foster more competition in the market or for the market, please be careful. And that comes at different levels. We have been talking about coordination at public enforcement level. What happened at private enforcement? How to privately enforce? Because all these obligations are embedded in data access rights. So, what happened if I don't know, come with an injunction in front of a court? How they will understand the scope of what the interoperability obligation or mandate is? And I think that also brings us back to this paradigm shift that I mentioned at the beginning, that we're becoming much more from the EU level interventionist. I have to recommend in that a paper that it's about to be published from a colleague of mine that tackles this issue and talks about it. His name is Jörg Hoffmann. And I really recommend you reading that, because it's not just addressing the data strategy, it's everything. It's not just potential collusion with interoperability and portability. We have also the same issue with sustainability. Now we have the guidelines, the horizontal, but we need to be careful that if we start creating a lot of super enforcement power bodies at the public level, the judges are the same, also, but then we increase bureaucracy too. And if we don't have a common understanding of what these terms entail and how they work, because at the end of the day, they are intertwining the data access, obligations, and rights, then we might end in a catch-22 situation where innovation might be harm, but competition too.
Thank you. We have 2 questions coming from the chat. The very first one, I think you can probably read it, but I will briefly read out the first part of the question. Could we have your thoughts on the fact that practices of self-preferencing and the use of data collected under a CPS for other services are prohibited respectively in Article 5.2 and 6.5 of the DMA? So who wants to take on that question before we move to the second question?
I think we want to read the second, because it's linked, and I think it explains.
Okay. Because the audience can't read. Sorry. Yes, these practices often even have pro-competitive effects, since they can allow an access controller to develop in markets where he is a new entrant and may compete with another access controller on a dominant or dominant incumbent. Let's take, for example, the marketplace of Meta coming to compete with the marketplace of Amazon. Yes, yes, please.
So I'm not going to comment on the DMA. I think I mean, stepping back, I think on the self-preferencing question, I mean, it obviously is a good question. I think the first thing I'd say is there clearly are coherent theories of harm around self-preferencing where you're a dominant firm and you're able to effectively leverage that market power into other markets. And self-preferencing is a thing in digital platforms because of the real importance of the user interface. So it's not, you know, in the old world where you had to tie products necessarily or kind of completely exclude competitors. You can do a lot through design of the interface, you know, who appears at the top of the list or in the buy box or whatever it is. So I think, I mean, certainly self-preferencing is an issue in digital markets. But I guess this is where my economist hat comes back in and says, I sort of agree with the question of that there can be cases where self-preferencing in itself per se is not wrong. What we need to tackle is anti-competitive self-preferencing. So that doesn't answer the DMA question, but that was a few thoughts on it.
Yes, Chiara?
Maybe on self-preferencing. So for me, it's like, it's also the Google shopping case, no? So in that case, it's also like the fact that the dominant firm is putting their own services before the services which are proposed by other. So in that case, I mean, I don't know, the example of the marketplace of Meta against the marketplace of Amazon, I'm not sure if it is there that the obligations on against self-preference would be the most effective. So it's rather like within the marketplace of Amazon, how the different products which are proposed are treated. So for me, it's rather like in this way that it will have like a strong effect.
Okay, so maybe we'll move then to the second question. We have sector regulations in different industries, including telecommunications. We also have Trade Competition Commission to enforce competition law in general. However, there was a difficulty, and there was difficulties and problems to identify some cases on which organizations should really have an enforcement power over such case. And it took pretty long before it was decided. From your opinion, how to solve the problem of overlapping power of different enforcement bodies? And I think it's an interesting question because I also, having followed a lot of the discussion between let's say the interplay or collaboration between privacy and competition authorities, there was a lot of discussion about whether it wouldn't be more effective to bring those privacy-related cases more towards to the competition authorities, because in particular before the GDPR, the competition authorities had just bigger fines, and this really made a big difference. I mean, the GDPR has kind of changed that a little bit, but I think this is also in that spirit. Maybe you may want to answer that question.
Maybe I will take it so that I also answer to the previous questions about the super regulators and the organization. So to reply to your question, is actually done at the national level. So there is no coordination. At my knowledge, I don't know, but I think that it's really like a choice of the national level, which competent authorities will be candidate for the different regulations. And for the super regulator, so also just to take a step back, is actually now in the digital market, in the digital environment, we see it a bit more, but in general, it is done all the time that there is not a consistency between different countries. So if we take France, we have a telecom sector, and then we have also some powers about the environmental impact on telecoms, which is not in other countries. And AGCOM in Italy, they have also power as a media regulator, which is not in case in France. We have two different regulators. You take Spain or the Netherlands, they have competition authorities together with the telecom regulator. So it's actually, it's already inconsistent. So just to take a step back on this, and still it's working. So, and maybe also another thing, so discussing with some convergent regulators, at the end you see you are under the same roof, but it doesn't mean that you actually really work together. And in France, there is always this discussion about the merging of the media regulator and the telecom regulator, so it comes like regularly. And at the end, what was decided last time, it was that we have a kind of a task force, it's called a pôle in French, so it's kind of, yeah, let's say a task force, working together on different subjects, which are of common interest and which are closely related. And we see that actually we work much more together in this way than what I see in other countries where there is a media regulator and the telecom regulator in the same company, in the same authority. So, I mean, I think it's sometimes actually structural coordination may also even work better than a merger of two authorities. So.
Just to support what you just said, I had the honor a while ago to talk to one of the FTC commissioners exactly about that point, where I basically kind of, this was at the time when we identified the need for collaboration as a key kind of policy objective. And we said, and I talked to her, and isn't it great that the FTC has the privacy responsibility and the competition responsibility, so you can basically do everything in-house? And she basically said, yes, but the moment when those two responsibilities or domain actually merge is really basically in my head when those two cases or those two issues basically come up. So just to support what you just said. Anyone else want to intervene? Yes, please.
Yeah, so actually this issue of coordination between regulators or overlap, in particular sectoral regulators and competition authorities, I've looked into that a few years ago based on practical cases, but also just thinking about it theoretically. And essentially there are two main issues. First of all, sometimes it's actually better to have two eyes looking at the same situation. So in particular for deterrence, it may be better. But also you could have, say, if authorities are sufficiently busy, then, you know, each one may be waiting for the other to act, so you can also get the opposite effect. And then the best thing probably there is to have clear rules about who takes precedence, who should move first. In the case of competition abuses, for example, in the telecom sector, the telecoms authority is the one that actually watches the market more closely, so there should be a kind of agreement that the telecoms authority contacts the competition authority if there are abuses and so on, and then they decide who intervenes. So talking to each other and defining rules is best.
Cool. We have reached the end of the panel. I'd like to thank you all and invite the audience to join me in thanking our panelists, and thank you also.